My name is Marcy Berger, and I'm the Member Services Coordinator here at AFSA. Welcome to AI Explainability by Design, how to ensure that your AI doesn't become a litigation nightmare, presented by Mayor Brown. A few housekeeping notes. To ask a question, use the question box on the side of your screen. I'll read them aloud to all following the presentation. The slides and recording of today's webinar will be available later today on AFSA's Webinar Resource Center. Finally, you'll receive a survey after the webinar is over. Please take a moment to complete it. Your responses help us fine-tune the program so we can target the issues that are important to you. On that note, let's get to the presenters. Alex Litigatio is a partner in the Washington, D.C. office of Mayor Brown's Litigation and Dispute Resolution and Financial Services Regulatory and Enforcement Practices. Alex practices in complex litigation, particularly on behalf of financial institutions. Alex often represents financial institutions in disputes arising from the wrongdoing of their customers, including instances in which customers have engaged in money laundering, securities fraud, tax evasion, and even human rights violations. As well as Alex often handles highly sensitive matters, such as cases in which financial institutions are alleged to have aided and abetted terrorism in violation of the Anti-Terrorism Act. Alex has spoken on litigation concerns arising from the use of AI and on the use of AI by financial services industry at numerous events and conferences such as LEN 360, the American Bankers RegTech Week, and the meetings of ABA's Consumer Financial Services Committee and the AFSA Operations and Regulatory Compliance Committee. Our other presenter, Eric Evans, is a partner in the Litigation and Dispute Resolution practice in Mayor Brown's Palo Alto office. He concentrates his practice on complex litigation and intellectual property matters, often focused on large-scale machine learning tools. He also leverages a prior career in information technology to provide advice on defending AI and machine learning tools, data and information governance, and cybersecurity. He is the co-chair of the firm's Electronic Discovery and Information Governance practice and a member of the Information Technology Oversight Committee. And with that, I'll turn it over to you, Alex and Eric.
Thank you very much, Marcy. Very much appreciate that. Eric, why don't you go ahead and kick us off?
In every major company's life, there eventually comes a litigation. And those litigations tend to revolve around the most important and lucrative investments that businesses make. For financial institutions, increasingly, those investments are going to be in the machine learning tools that identify where to focus, for example, debt collection, or how to price loans individually for particular customers to make maximum return at minimum risk. These tools are going to affect huge amounts of revenue and money flowing around in the financial system, and huge amounts of money attract plaintiffs' lawyers. My first really deep experience with how plaintiffs' lawyers can take advantage of the nature of a machine learning tool was in a false advertising case for a very big advertising company. This company places ads trillions of times a day on websites all over the world. And in that process, it uses a machine learning tool to predict how particular ads on particular websites are going to perform. And this tool tries to adjust the bids that advertisers make for particular ad displays based on how likely that ad is to produce a good result for the advertiser. Now, you can imagine that this kind of tool will impact billions of dollars a year as they move back and forth through the advertising world. Plaintiffs looked on this advertiser's website and decided that there was something about a disclosure on that website in the help center that wasn't particularly accurate from their perspective on how this machine learning tool worked. So they brought a lawsuit back in 2011, and the case is still going on up to appeal. They represented a class of, for their purposes, every advertiser in the United States who had placed an ad using this service. And as part of that process, they asked for all of the billing and ad placement records that this machine learning tool had generated since 2004. We were only able to get a basic approximation of how many records were involved because that number changes so rapidly, but it was easily over 1 trillion. And this tool is so important to the business and so large in scale that every aspect of it, from the computers that run the tool itself to the file system and searching systems that are used to parse the logs that are thrown off and generate bills, is custom. And even with that custom development and very, very smart engineers spending their careers optimizing this tool, it still takes 2 or 3 weeks to run a search across all of those billing records. And so it was clear that there just wasn't any practical way around this. I mean, it was clear to us, it was clear to plaintiffs, but that was good for plaintiffs because that gave them the freedom to have their expert based on sort of, you know, the kind of things that will get you qualified as an expert, which is being able to say that you are in a way that a judge will believe, to essentially make up stories about what the tool did and leave very few options for responding to those stories without somehow finding a way to produce this information in a way that would make it admissible as evidence. And, you know, because we're good litigators, we found a way around that, and the case is effectively resolved at this point on by other means. But that pattern shaped the entire development of the litigation, and it gave me a deep object lesson in how important it is and how difficult it is to defend this particular kind of new financial tool that is going to be important to every financial institution and every business I can think of. Alex, would you like to take the next slide?
Yeah, absolutely. Thank you, Eric. So I think the thing I want to bring home here is, for the problems that Eric is talking about, which is a problem of having, you know, potentially enormous liability, enormous management distraction, and enormous pressure from the court, there's not an easy after-the-fact bolt-on solution. The data that you might want to use for your own defense might not be saved or might not be accessible. The people that you want to explain things in terms of what happened might have left the company or might not really be qualified to do so or might not have given thought to the right issues. And explaining the process after the fact can be a bit like, in my mind, someone asking you to explain the ingredients in the baking process for a cake that you ate yesterday. So I think the takeaway for this slide is simply that do not think that this is something that you can get yourself out of necessarily very easily if you haven't given it thought before the litigation commences. Eric, do you want to take the next slide?
Yes. Now, what machine learning tools are is a combination of 3 components. there are inputs into the tool, there's the tool itself, and there's the output. And all three of these aspects of the tools produce a new and profoundly difficult set of challenges for companies defending the tools. First, the inputs to the tool are often enormous by conventional standards. There's a reason that before people started using the buzzword artificial intelligence, this kind of tool was called big data. It's big, and it can often be so large that it is logistically difficult for the company to retain. It will also be, in most cases, data that's extremely complex. It may be drawn from many sources and then fed into a data lake. And it may also be extremely sensitive, especially for a financial institution. The important data, the data with real business value, will often contain information that's subject to all kinds of regulatory regimes. In addition, because the machine learning tools are often set up sort of just to produce results, and engineers may not focus on making their process explainable for later, they may not keep training sets of data that they use in the development process and then don't need to use again. The next aspect of the tools that causes substantial difficulty is the tools themselves, the code that analyzes the inputs and produces the outputs. That code will be incredibly complex. The engineers who create custom machine learning tools are brilliant people with deep backgrounds in usually several different subjects, often doctorate and postdoctorate studies in several areas of technology. And they are solving what they think of as problems. And they tend to describe their solution as a fix to a problem. And that short description of what they're doing, which they will put in their communications with each other, will be easy for plaintiffs and a jury to focus on, while the complexity of the tool will just go right over their head. Engineers tend not to sort of quietly suggest that there are multiple options to address a potential issue. They tend to advocate their particular way as the only good way. And because the tool is so complex, it can be very difficult to put together an explanation for why, that engineer wasn't quite right or didn't consider all of the context in the statement that he or she made. Finally, the outputs from the tool will be every bit as big as the inputs, and they'll accumulate, assuming that the tool logs transactions that are essential to its functioning and the business intelligence that it's describing. They'll also be complex and incredibly sensitive. Again, in the financial services industry, you'll be generating predictions that will drive transactions that again are subject to all kinds of regulation. And the outputs may not be reversible. That is, it may not be possible to look at the output and then work backwards to why the processing tool itself made the conclusion that it made. In the end, an artificial intelligence and machine learning tool will look an awful lot like a black box, where information goes in one side and intelligence comes out the other, and it's really hard to explain why the information is translated into the intelligence. And black boxes are extremely difficult to defend. You can't put the machine learning tool on the stand, and someone needs to be a witness for that tool. Alex, did you want to talk about artificial intelligence inputs on the next slide?
Yeah. Let me, and I think, Eric, I think you covered off a bit of this. So,
yeah.
You know, I think a lot of people are familiar with Moore's law, which is the idea that computer power doubles every so often with regularity. But the truth is, data does too. The footprint of available human data has been doubling every I think 18 months since the mid 1800s, and it continues on that trend. So we're talking about a world where we have a vast amount of data that is sort of out there. And that really has been, if you look at what is fueling today's sort of artificial intelligence, machine learning revolution, it's bigger data, it's smarter algorithms, and it's faster computing. And so those bigger data sets really are the fuel that the AI feeds on. So in terms of, you know, when we're thinking of discovery challenges, you really should be thinking, you know, that we're talking about vast amounts of data, and particularly, you know, as we're talking about more sophisticated algorithms to go with it, sort of the more sophisticated the algorithm, the more data it's going to need. And a lot of times it's looking at sort of all the available data. So if you look at the use case where we're trying to determine who's creditworthy and determine how to price credit products for those borrowers, we may be analyzing their transactions, their behavioral data, their Facebook friends, any of a number of things. So we're talking about an awful lot of data there. Eric, as you said, that data does tend to be sensitive in many cases. You're talking about personally identifiable information, or at the very least, things that customers find confidential and sensitive about their spending habits. You're talking about machines that really, they learn as they go, right? So one of the joys of machine learning, and one of the things that's great about it, is arguably it gets a little smarter with each transaction it processes. With each loan it extends or declines, it knows a little bit more. But the flip side of that is, you know, you're dealing with a situation where the data that the machine considers relevant and that it's using for its own sort of internal weights and assessment is constantly in flux in many cases. And so going backwards to identify that, you know, can present an enormous challenge. And then going to the same thing, which is, you know, you've got this machine that learns, and hence something of a game that moves as you play. A lot of times the data is overwritten. So, you know, you train a machine on 10,000 loans, and then it looks at then it comes up with some internal weights and measures based on that as to how it's going to predict loan number 10,001. And after it predicts 10,001, it changes those weights a little bit. It may overwrite all the internal weights from before. And to the extent that it looked at thousands of factors, it may not keep a record of those thousands of factors it looked at up into learning to rank or score loan 10,001. So you're really dealing with a situation of vast data, sensitive data, evolving data, data that may not be retained. And all of these, as we'll discuss more, can really present a challenge when you're in a litigation context that is itself very data-driven and you're trying to explain what you did and why. Eric, do you want to take the next slide and talk a little bit about the black box?
Yes. The great difficulty in defending a machine learning tool is that we have two things we can identify. They may be problematic, they may be enormous, they may be complicated, but we can identify them. That's the input and the output. But between those two is the code and the math that converts the inputs on the left side of the flowchart usually into the outputs on the right side of the flowchart. And this code can be extremely complex and beyond any reasonable person, even the engineering managers driving the project, to understand fully and explain. And often what the AI tool will derive are whole new unexpected insights from the data. And that has a lot of business value, but unexpected is also a way of saying really difficult to explain to a judge and jury. And so if your tool is producing unexpected and interesting business results, you need to have some mechanism for explaining why it produces those results. Because that is honestly the question you'll need to answer when a plaintiff comes after your tool for producing some pattern they can base a claim on. Alex?
Thanks. So what I have here on this next slide is a cartoon that illustrates what Eric was just talking about. If you don't know this cartoonist, I think probably quite likely a lot of your engineers or the engineers and software programmers you will deal with do, and they may even think that it's cool that you know about it and read it. The couple things that I'd like to bring home here. So, you know, this idea of you put data in and you get answers out, but you don't know what happens in between, works reasonably well in some instances. So, for example, if you're trying to distinguish between horses, pigs, sheep, and goats, and if the machine's not giving you right answers, you can pretty quickly say, well, the machine has gotten this wrong, this isn't a pig, and I need to make some adjustments until it can recognize it as a pig. Here's how things can get kind of interesting, though, and this is an example you can actually see if you go to the Wikipedia page on AI. A machine learning system was trained to basically do this, tell apart different farm animals, and it did it very well in practice. And then when it was released to do this in the real world with real animals, it could tell, you know, sheep and pigs and goats, but it couldn't tell a horse to save its life. And the engineers went back and said, gee, it did well in training. I wonder why it can't tell what a horse is in the real world. And when they looked into it, they realized that in the training set, every picture they'd given the machine of a horse had a little teeny copyright symbol in the corner. And so the machine had learned that a copyright symbol was a horse, which of course doesn't work so well in the real world. And this really illustrates that when you don't know what's going on, you know, there can be some very funny things going on in the middle there. And sometimes it's pretty obvious if something's getting it wrong, if it's calling a horse not a horse, or if it's calling a pig not a pig. But sometimes it can be very subtle as to whether something's wrong, if it's saying someone is a little bit more creditworthy than someone else. And this can, you know, result in wrong answers. It can result in accusations of unlawful and unfair bias. And so it's something, and it can also, you know, even result in some internal debates as to, you know, why are we getting the results that we're getting? So, you know, as we talk today about different ways of thinking about being able to explain what's going on, I would say it's not only good for the litigation, which is really the focus of today, but it actually is good business in the sense of you'll have a better idea of why you're getting the results you have and the degree to which you can be confident in them. Eric?
Yes, and I'd just like to amplify what Alex said there. When we're talking about how to defend an AI in litigation, we're really talking about having a good story that explains why the AI does what it does. And that good story is valuable internally and with regulators, even if there's no litigation. So the better you can explain your AI internally and to regulators who may be concerned about it, the better your chances are in litigation. But the internal explanations and the regulatory explanations are values in themselves. We've already talked in general terms about the outputs from artificial intelligence, but they are a key aspect in planning to defend a machine learning tool. The outputs from a machine learning tool will often be as big as or bigger than the inputs, and they'll accumulate with the life of the tool. The tool will throw off its predictions about creditworthiness or, for example, where a real estate fund should invest in its money, and they will often be extremely complex and only explainable with reference to the particular machine learning tool. In addition, because these outputs are tied directly to the tool, it's hard for the plaintiffs and the judge and the jury to look at them and understand them. We've all gotten used to the traditional productivity tools that are out there, email and word processing and spreadsheets. And so when you have a conventional business decision driven by people who use those tools, it's easy enough to put a couple emails up on the board and a couple PowerPoint presentations and describe the thought process that results in the decision. With an AI, you have the outputs, and pretty rapidly, a discussion of the outputs is going to turn into an argument between the parties' experts. And in that argument, plaintiffs have an advantage because they want to tell a simple story about a very complex tool, and practically speaking, they get to. Because again, an expert is whoever can convince a judge that they're an expert. And plaintiffs' experts will be selected and will often have extensive experience in telling a simple story that isn't 100% wrong, but is very convincing to a jury. And defense experts are generally tied much more closely to the actual story. And that means that even if your outputs are explainable on some level, you will still be on a meaningfully plaintiff-friendly playing field when it comes to actually presenting them to the judge and the jury. Alex, do you want to talk about the panda problem?
Yeah, absolutely. And so I recognize that this is a little bit of a silly way of explaining it, but the science seems to indicate that memory is a creative process. So I often find that it does help to do things in this type of a way. So pandas, they're animals that are known for living pretty comfortably and happily in their native habitat, but not doing especially well when they're transplanted out of that environment. And similarly, AI outputs, are often usable and comprehensible in the system surrounding the AI tool, but they can be pretty hard to export in a meaningful fashion outside of that native software environment, at least in some cases. And what do I mean by that? Well, sometimes the AI information, because of the vastness that Eric was talking about, has to be stored in deep storage, meaning that it first has to be moved to fast storage before it can be searched and utilized. Sometimes it's going to be stored in a proprietary format, something that I would call maybe exotic as compared to things like, the tools that Eric was talking about, spreadsheets and comma-separated values and that type of thing that are well known. And depending on the system, some of them are, have data that really can only be searched using customized search features that are designed in-house, and that quite frankly are sometimes only understood by in-house people or even a subset of in-house people who are in that space. So that's just sort of a little bit extra on why it is challenging to deal with the data outputs. Eric?
So this is an illustration of the world that litigators live in. When you're taking your ship through the icebergy waters of business and you see an obstacle in front of you, chances are it's an iceberg. But plaintiff's lawyers aren't like icebergs. They're like Godzilla. An iceberg, if you steer around it, you'll be fine. But Godzilla will chase you. And plaintiff's lawyers, especially class action plaintiff lawyers, will go after piles of money. They want their cut, and they'll do what they think they need to get there. As I've said, for them, that means telling a simple story and pushing defendants and their experts off the facts. And a machine learning tool that isn't designed from the beginning to be explainable and just remains a black box is an attractive target for these plaintiffs' lawyers. They like them because they can tell a simple story about what's in the black box, and because the black box really is a black box, it's hard to answer that story. And so now, a plaintiff's lawyer is not just a regular old iceberg you can steer around. They'll come after you. Alex?
So I think what we're going to do is we're going to talk about these sanctions that plaintiffs' lawyers use as a lever in a bit more detail over the next few slides. So I won't belabor it too much here, except to say, I think as you'll see in the coming slides, that, sanctions ends up being one of the levers they use to put pressure and settlement pressure. It often is something that some plaintiffs' lawyers would prefer to get to instead of the merits of a case. And that inspires them to sort of pre-sanctions mischief, where they're going to try to make things as demanding and painful as they can, hoping that they'll be able to leverage that. But that said, why don't we actually explore this in the context of some of the things that come up in litigation and see how it plays out? Eric, why don't you start us off with document preservation?
Yeah. One of a plaintiff's lawyer's favorite tools is a threat of sanctions for failure to preserve evidence, or spoliation. And machine learning tools, because they're sort of custom designed to produce business insights, may not be configured to tell a particularly compelling story about document preservation. In the regular world where most people work, it's pretty straightforward to preserve documents. You keep a person's email account, you collect or preserve their productivity documents, you preserve the shared drives and document management systems that they have access, and you're pretty much done. Like when people write a new email, it goes into the preservation kitty. When they make a new document, it gets preserved. But machine learning tools may not do that. They're designed to produce actionable business insights. They're not necessarily designed to preserve all their work so that you can reconstruct how they did it. For example, the tools often won't log the intermediate information that they calculate during the analysis process, and without that, you can't really work backwards through the tool to determine how it reached a particular result. Now, this is just a design decision, and it's a perfectly reasonable design decision from a technical end, but plaintiffs will present it as an attempt to sort of hide the ball, or to eliminate evidence that would be helpful to them. This isn't necessarily a winning argument, but when the tool doesn't retain key values that are used to calculate the results, it can be complicated to explain that to a judge. Also, when the tool gets its information from an outside database, that database may be set up to overwrite particular values in particular fields as they change. This is a standard database management practice because it enables the database to be smaller and perform faster, but it may make it very difficult to reconstruct the actual inputs into the tool as of the time that a transaction occurred. For example, if a customer has a a database entry that says they're one particular kind of member, and then changes their membership status, and that prior membership status is not stored, it may be quite difficult to reconstruct how the tool would have reached its conclusions before the membership status changed. Again, this is a perfectly reasonable decision from a technical level, but plaintiffs will claim that this kind of practice is spoliation. And again, it can be difficult to present proof that it's not to a judge. Judges are not technical experts, and they tend to assume that large and financially secure businesses are able to do most things to preserve information. That puts financial institutions and larger businesses at a real disadvantage in spoliation fights. Alex?
Thanks, Eric. So talking about document production, which is the next thing. So at the outset of the litigation, of course, you have preservation obligations. As the litigation goes on, you likely have document production obligations. And I think most of us are familiar with the general obligation, which is that unless information is privileged, if it's relevant, you're probably going to have to produce it. However, there is a rule of proportionality in federal court and a rule of undue burden in state court that says if what's being requested is out of proportion to the needs of the case, if it's too much, you can resist producing it. Or if it's unduly burdensome, you can resist producing it. The trouble, of course, is that the devil is in the details, and we don't really know exactly where that line gets drawn for AI because we haven't been through it a lot of times in the court for AI, and because every system is different, and because that's going to be sort of addressed each time on the specific facts of the case. The way this tends to get worked out in practice is that there will be discussions and letters and arguments between lawyers on both sides till hopefully at some point they come to an agreement. If they don't come to an agreement, they're going to need guidance from the court on what does and does not have to be produced. That guidance from the court, well, I mean, it's good because it gives you rails to follow in production, but it's bad because it gives you a third rail, which is to say, if you step off, you can get zapped. Once the court has an order for production, the failure to produce as the court thinks that it is ordered can subject you to all manner of trouble, sanctions, and the like. So given that this is sort of the rubric we're dealing with, we have something of a difficult situation with plaintiffs' attorneys, and here's how they will try to exploit it. The first thing you should expect is that they'll make just very broad discovery demands, demanding everything you can imagine and maybe a bunch of things you can't. The second is you can imagine that those demands will seek training data and will seek very sensitive customer data that they're going to want to look at. They will seek data that is trade secret data, quite likely. If you have some of this outsourced to a third party, they will impose the burden on the third party, the vendor that you're working with, perhaps trying to drive a bit of a wedge between you and your vendor, in which the vendor is being asked to share trade secrets or information that it just doesn't want to share. And once that's done, whatever it is you produce, you should expect that there will be arguments that it wasn't enough, that it wasn't right, and so on. And as a solution, the opposing counsel will likely suggest a couple of different things, one of which is that their engineers be afforded direct on-site access to your database and your AI tool and so forth. This is undesirable. You really don't want strangers to your business who have interests hostile to your business running around inside there. And they will seek court orders directing you to produce things or directing what they tell the court is a reasonable compromise, even if it isn't. And all of this by way of saying, it's a build-up to the potential for sanctions. And even if you never get that far, simply, having you run around chasing after all these different things can be a big distraction to simply getting your business done and moving on with your life. And that of course, is all part of the strategy on the other side. Why don't we turn now to admissibility of evidence, which is, I think, what comes after this document discovery. Eric?
Yes. After document discovery, the parties have to actually start using evidence. And to use evidence, you'll need to authenticate it. and that means proving that it is what you say it is. And because plaintiff's attorneys are plaintiff's attorneys, if the information that you've produced after the incredibly painful production process doesn't help their case, plaintiffs will fight to keep it from becoming evidence. And with outputs and other information out of machine learning tools, they actually have a decent chance. Generally speaking, there are 4 factors that courts consider when deciding whether complex data is admissible, and those are the quality of the data inputs, the complexity of the algorithm applied to the inputs, whether the question that the court's addressing is routine or novel, and then whether the outputs can be tested and verified. And after we've gotten to this point in the presentation, it should be clear that those aren't foregone conclusions for a machine learning tool. Depending on how carefully your engineers and designers have thought about the quality of the data inputs, that may not be an issue you want to fight on. Machine learning tools often have incredibly complex algorithms that would be very difficult to explain to a judge who's making an admissibility decision. The problems that machine learning tools address are very often novel, and it can be very difficult to test the output of a tool against the inputs to make sure that the tool was applied correctly. It may be difficult to define correctly, given that the tool may have changed substantially between the time that the transaction that matters in the case occurred and its state now. It may be difficult to reconstruct the tool as it was then to test and verify the outputs. So all of these factors are attractive targets for a plaintiff that wants to keep information from the tool out of evidence so that they can rely on their experts' assertions about what the tool did instead of documentary evidence that would show what it actually did. And they will use this admissibility issue as a wedge to get further discovery into the very most sensitive aspects of the tool, the deepest trade secrets in the tool, so that they can put pressure on a defendant to give up and back off the assertion, the attempt, to introduce the evidence, because they understand that sometimes the settlement value of the case can be smaller than the risk value of disclosing information about the tool. And all of this gives them a chance to drive the facts and evidence in their direction and tell the judge and the jury a simple story that leads to them winning or to a substantial settlement that drives their business model.
Okay, so we've spent quite a while, and you've been patient as you've listened to us talk about this perfect storm of plaintiffs' attorneys being difficult, AI being difficult, and the litigation rules being difficult. So now I think the question is, what can you do? And we wouldn't be having this conversation with you if we didn't think, based on having lived through this, that there were some very practical and immediate things that could be done. And those things go to, as you can probably imagine, the idea of what's explainable and what isn't, and explainability. Eric, why don't you just talk for a minute on this next slide about what explainability is, and then I will talk about some human-oriented solutions.
Yes. So explainability is a short word for making a machine learning tool that people can understand. And generally, it's divided into three aspects. The first of those is transparency. And transparency is easy identification of what the tool does. So, for example, if you generate a, say, 4-page summary of how the tool operates that's accurate and understandable at for first year of college, senior and high school reading level, that's kind of the ultimate example of transparency. The second aspect is interpretability, and that is easy identification of how the tool weights the inputs and gets to its results. And think of this as a high-level flow chart that you could use and list of input fields that you could use to sort of step through how the tool takes an input, applies math to it, and produces an outcome. So it's more than, it's reaching out beyond the tool into the inputs and mapping how the inputs travel through the tool to get the outputs in a way that you can present to a regulator or a higher business decision maker within your organization, or in the worst case scenario we're talking about now, a judge or a jury. The third factor is provenance. That is an easy identification of where inputs come from and where they are. So many machine learning tools analyze information in what's called a data lake. And provenance would mean that within that data lake, you can trace all of the data that's fed into the tool back to where it came from and why it would have business value in the tool's calculations. And a tool that has these three things, transparency, interpretability, and provenance, will generally be explainable. I mean, you can say what the tool does. You can map out how it takes the inputs and brings them to the outputs. And you can explain what the inputs are and why they're reasonable inputs. And what's really interesting is that when I run through those three factors of explainability, they sound an awful lot like those 4 factors for admissibility. And so in the end, I think we're talking about the same thing, because a tool you can explain succinctly to internal decision makers at the company and regulators. There's also a tool you can put in front of a judge and jury and explain to them. And so explainability is a good business decision, but it's also a good litigation decision.
So let me talk then a bit, following up on what Eric is talking about. It's about a human-oriented solution to explainability. And I think in all the talk of AI and all the excitement of technology, from a business, from a litigation, from a regulatory, from a practical perspective, this is one of the most important things, is just to be able to paint a really clear picture. And I think all the stakeholders pretty much are going to want this picture to be painted, a clear picture that it is humans in the driver's seat, and in particular, that there's a chain of command. And that chain of command most likely starts with management or even the board saying exactly what it is that the AI is supposed to do, and them instructing the scientists, the programmers, and the engineers that the AI does it, and then the AI being in the backseat to the scientists, the programmers, and engineers doing exactly what it's been instructed to do. And so you want to have a paper trail and a record of a clear set of specifications from the management team to the scientists and the software engineers about how the company wants the tool to work. and recognizing that those specifications are business decisions, not engineering decisions, and certainly not decisions of a tool making up its own mind about how the world should work. One thing that we advise a number of our fintech clients and others is to even think about having an outside advisory board that will advise on some of these issues, particularly AI, as it starts to get into ethics, as it starts to get into making decisions that really affect people's lives. Having an outside advisory board and bringing in some of the people who are maybe a little critical of our space in financial services. Not the crazies who are out there who are really just, you can never get along with them, but people who are interested in making critiques from the point of view of financial services is a valid industry serving a social good, but it can be improved and I'd like to help improve it. Those critics you can work with, and I tell you, if you get them on an advisory board, they can be your best friend in a lot of ways. They can spot problems before they occur. They can be an interesting sounding board. And when the crazies speak up, they can speak up on your behalf saying, you know, what your position is. And then it becomes just a, you know, she said, he said, she said, she said between various advocates on the consumer-friendly side. As well involved in this human process, the company's e-discovery and information government team should specify to the data scientists and software engineers how the company wants wants to store and wants to be able to access the inputs, the outputs, the change logs, all that good stuff. The company's legal team and the compliance team should be consulted on everything I've just discussed. And then there's some special categories that the company should make sure it has people who are appropriate to handle what I might call an AI sustainer, which is someone who is available to continually test and modify the AI tool to make sure that it's working the way that the management team said it should work from a business perspective and the way that it is supposed to work from an e-discovery and information governance perspective. You know, so you could have a situation, for example, where the instruction is, let's make some loans to millennials. Let's figure out which millennials are creditworthy outside of traditional credit scoring, and let's use some alternative data, and let's figure out the ones that are creditworthy, and let's make some loans to them. And you may discover in the process of doing this that you have a spike and that you're finding that most millennials who are getting this credit are in existence in Colorado. And you dig a little bit deeper and maybe you find out that those are millennials who were there because of the green rush, the gold rush for the marijuana money. Now, your company may have a policy at the top about whether or not it does or doesn't want to have exposure to that type of risk in business. If you're just very narrowly looking at the tool, you can have some trouble there. But if you have a regular dialogue where you have these sustainers who are looking at, you know, how are these things functioning? Are they functioning consistent with policies? You're going to have an ability to steer things the way you want them to be steered and not be caught by surprise. And the last category that I would say is to have some what I would call AI explainers. And these are people who actually can just sort of explain in plain English how things work and can be a sort of a liaison who goes around and talks to all the different groups, make sure they understand, make sure the communication is happening smoothly, alerts people to things they may not have missed for lack of understanding about how to talk between tech and business, and be ready if and when called upon in a litigation to explain what's going on. Eric, do you want to talk some about some of the technologically oriented solutions that might make sense?
Yes. As well as addressing the human issues, there are also some relatively basic technical steps a company can take to make it easier to explain and track its machine learning tools. The first one of those is using a code development platform that allows for easy tracking and auditing of the machine learning code. You'll want a tool that lets you very, very carefully track changes, see who's taking code out, see who's checking code in, and also managing change applications very, very carefully so that you can show when the company made changes to the tool and optimally exactly what the engineers who made those changes thought the changes would do. As a side effect, and it's a good side effect, you'll also be better able to protect the trade secrets embodied in that code, which are some of your most important assets. In addition, there are a very new set of technical tools that are intended to automate the explainability process. These are called XAI, or explainable AI, and while the tools are still developing, they're definitely worth a look to see if they fit your development model. If so, like, think hard about jumping in early on these tools. It's worth assuming some technical risk, because, you know, I can't say that any particular implementation of these tools is going to be the winning one, to reduce the legal risk. Alex, next slide.
Sure. Thank you. So, you know, as you go through these, and we've talked about things that involve a lot of technology, we've talked about a lot of different stakeholders, from management to the data scientist side to the legal and compliance side. We think it's very important to have an expert in the room. You really want, and Eric, if I can pick on you, you really want your Eric Evans in the room, someone who's litigated through it, been there, lived it, done it, who speaks with the voice of experience, and someone who really has, you know, helped companies to sharpen and improve these tools on the front end. Someone who, you know, again, Eric, if I'm to pick on you, someone who's actually, you know, been through it on the tech side as well as the legal side. It's just going to make things very much more smooth and keep you from falling into some pitfalls that are avoidable, but that if you haven't already stubbed your toe on them once, you know, you might not know to avoid. Next.
Yes. And Alex and I and our colleague Reg Gakey have a fuller, detailed article on these issues. You can get it at the URL up there, tinyurl.com/YYQQVH4G. You'll be able to see that in the PowerPoint presentation. And if you want any more information or just want to sort of talk about these issues, we'd absolutely love to do that. Please get in touch with us.
So we have just a few minutes. Marcy, do we have any questions?
Yeah, so the first question is, what do you think the biggest challenge when it comes to making sure an AI system is litigation ready? You know,
Eric may have a different answer than me, so I'll let him speak as well. But I think my view is it's actually one of focus. What ends up happening with so many of our clients is they just are busy with the business day to day. They're putting out the fires right in front of them, and things change with the AI system, and then they change a little more, and they change a little more, and all of a sudden, you know, if they haven't been keeping on top of it, it's just not the way they envisioned it to be, and they're having trouble going back and reverse engineering and finding things out. So it's really, I think, a lot about acting now, acting right away, and not getting distracted. And it's certainly understandable if you have to put out a fire, but if you do, come back to it and make sure it's still, that your sustainer is saying it's still doing what it's supposed to do.
Oh, I would agree. And in the litigation context, as people are putting out those fires, they will be sending each other email messages that a plaintiff's attorney will want to put up on a PowerPoint in front of the jury. Because when people have what they believe is an urgent problem in front of them, their register changes, and they say stuff they'll later wish they hadn't. It's just human nature, but that kind of like short-term focus creates documents that are messy long-term. And a little bit of planning and a little bit of attention to this issue can help reorient their thinking so that maybe they're a little slower in making a really strong statement in an email.
And I think that comment right there is just the perfect way to sum up. If there's one takeaway, it's a little focus right now makes a huge difference. Marcy, I'm sorry, I think I may have cut you off.
Oh, you're good. Great question. Another question is, are there specific examples of how to approach the use of AI so that inputs and outputs can be narrated about more clearly?
I'm sorry, I apologize, but say the question one more time.
Yeah. Are there specific examples of how to approach the use of AI so inputs and outputs can be narrated about more clearly?
That's a good one. Well, what do you think, Eric?
Yeah, that is a good one. The advice I'd give there is really data governance advice. And these tools sort of live in a relatively late stage in the data governance life cycle. But when you're choosing the information fields to add to the tool, if you make that choice in a careful and considered and documented way, you'll have your provenance for explainability, but you'll also have a better decision. And in many ways, the advice that we're giving comes down to, like, think carefully about where the machine learning tool can go, and keep a record of what you're doing so that if you have to explain it later, it's easier to do. And it would be terrific to be able to give broader advice than that, but each of these machine learning tools is kind of designed custom from the ground up at this stage, and that advice will end up, the specific advice will vary a lot depending on what the tool is doing and the information that it's relying on.
So I have seen people optimize for making things easier to explain, and there's a cost in the sophistication of what you can do and the speed at which you can do it for that at this point. So let me explain what I mean by that. You can build a model, and there are people out there who do this, that's a static model, an old-fashioned credit scoring model in which doesn't use machine learning itself and doesn't move as you play. But you can then use machine learning to find new features. So maybe I find that everyone who drives a red car is more likely to get a ticket, is more likely to be a bad credit risk, and I add that fact, and then I check that factor out, and I find out that I think at least in the area where I'm working, it's not biased against minorities and protected classes. And then I feed that into my, so I found that idea with machine learning, I found that correlation. I now put it into a static model in a way that's very understood how much it's weighted, where it fits in. So I've used machine learning, and I'm very explainable, but what I've done is I've compromised some of the best features of machine learning. And that, I think, is really somewhat true at every level. There's a continuum where if you use a simpler machine learning tool, such as a linear regression, a random forest, as opposed to the deep neural networks that are the most sophisticated, you get more explainability. So that's some of what I've been seeing, which I hope goes to the question a bit.
Thank you both.
Thank you, Marcy. I think we're out of time and out of questions, so very much appreciate this opportunity, and hope folks found it useful.
Yeah, thank you so much, Alex and Eric. Today's slides and recording will be available later today on the Webinar Resource Center. Thank you so much.